Okay, Dave, we're ready to get going.
Okay. Well, welcome everyone, and we appreciate you all participating today in the event that we have. My name is Dave Zapponi. I'm the Executive Director, otherwise known as the Executive Council of Homeowners. We are based in San Jose with satellite offices in Tracy and Laguna Hills, California. Thank you for participating in the ECHO live stream event on our COVID-19 board decisions covered by insurance, featuring Elliott Katzovitz and Sandra Gottlieb. ECHO is a statewide nonprofit association created to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connection. ECHO is 47 years old, which makes it the oldest association representing collective interests of HOAs in the state of California. It prides itself on providing educational programs to build stronger communities. Before we move on with the program, please note this webinar is scheduled for an hour and a half. Please feel free to leave the meeting at any time. We will mute attendees during the presentation to help with sound quality and to assist speakers in developing concepts. Please note that we use the chat feature for technical issues, and the Q&A feature for content-related questions. You may ask questions throughout the presentation using the Q&A feature. We will be vetting and answering questions as they come in. Please note that we have more than 250 people registered for this event, so we might not be able to answer all of you. Please be courteous and respectful of the meeting participants at all times. We reserve the right to mute or remove participants at any time and for any reason. The program is copyrighted by ECHO and will be recorded. We do not give permission to others to record the meeting without prior authorization. A copy of the recording along with presentation slides will be emailed to registered participants within 7 to 10 days. ECHO is a nonprofit corporation which has and strictly follows an antitrust policy. It is available for review on our website at www.echo-ca.org. Finally, none of what is said during the meeting shall be construed as specific legal advice from either the speaker or ECHO. If you wish specific advice, we encourage you to ask your attorney. Thank you, sponsors. Our program sponsor today is Katzovitz Insurance Agency and SwedelsonGottlieb. Q&A questions sponsor is Akim Painting and Allison Insurance. Registration sponsors ASAP Collection Services, Applied Reserve Analysis, and B2B Consulting Group. At this time, we will hear a few words from our program sponsors. Sandra?
Actually, I think Stephen is going to speak for us today.
Thank you, Sandra. Hi, my name is Stephen Brindle. I'm a senior associate with the law firm SwedelsonGottlieb. I'm based at our firm's San Francisco office, as you can see. We also have offices throughout the state in Los Angeles, Orange County, and Palm Desert. Since 1987, SwedelsonGottlieb has been solely serving community association clients with services such as amending governing documents, collections, and dispute resolution. Recently, we have been helping community associations to resolve issues from COVID-19, including issues relating to employment, insurance, contracts, privacy, risk mitigation, liability, and emergency rules. SwedelsonGottlieb values our relationship with you. We hope that you will think of us when your community association has legal needs. You can find more information about our firm at our website, lawforhoas.com, or on our blog, hoalawblog.com. We are still working and available by phone number and email as provided in this presentation. Thank you.
Well, thank you very much, Steve. Elliott?
Yep. So I'm an insurance broker that has been specializing in condominium associations for 20 years. We represent associations going all the way from Napa to the Tijuana estuary. I specialize in complicated HOA insurance, all lines of it: earthquake, fire, liability, D&O, fidelity bonds, and have been doing nothing but associations for the last 20 years. And we can handle either complicated fire issues that you're dealing with right now, as well as pure brokerage to make sure that you're getting the best value for your dollars, which, given the recession, is a critical factor these days.
Okay, well, thank you very much, Elliott. We appreciate that. Elliott Katzovitz is the owner and principal of Elliott Katzovitz Insurance Brokerage, which is an insurance brokerage that specializes in condominium associations. Elliott Katzovitz has been focused on insurance of condo associations for the last 20 years and is author of numerous articles and author of the Insider's Guide to Community Associations Insurance. Sandra Gottlieb is one of California's leading community associations attorneys. She is a founding partner of the law firm SwedelsonGottlieb, which was formed in 1987. Sandra's extensive negotiating skills have given her the ability to work with volunteer board members, associations, managing agents, opposing counsel, and provide sound counsel regarding association operational issues. As the firm's managing partner, Sandra also leads the transactional team at SwedelsonGottlieb. Sandra's experience and expertise in representing California community associations allows her to also counsel on many different matters and issues that impact California homeowner associations. At this time, I'd like to welcome Elliott Katzovitz and Sandra Gottlieb. Thank you.
Thank you, Dave. Thanks for having us. We're so appreciative.
Yep, thank you for having us speak today. Great opportunity.
Okay, we'll start the presentation.
So I am going to start with what do boards need to review to open. You know, we always say, oh, make sure you look at your governing documents. And you need to do that, but in this order of hierarchy, we see that our CC&Rs are actually going to be fourth on the list. We need to start with state orders, county orders, city orders, then of course the CC&Rs and the insurance policies, which are a clear topic for today. For the operational issues that they need to deal with to either keep communities and their amenities closed or to open them up. We know that some cities and counties have actually said, that's great, state. Thanks so much for this obligation and liability. We don't accept. And we know that over the last national holiday in Big Bear, California, we have a county that said, you know what, not so much. We're not going to do this. I think it's a great idea that you have masks and social distancing, but we're not going to enforce it. We're not set up to enforce it. We don't have the personnel to do it. And frankly, they said, we don't have the insurance to do it. So it is a little bit frightening when we have to deal with a county that says, we recognize this is here, but we're still not going to do anything about it. We do have a recent strike force that's been enacted on early part of July, made up of 10 different governmental agencies throughout the state, coming up with protocols that will apply, if accepted, to all of the counties. We do not have any definitive action items from this strike force as of yet. Elliott, what about, does insurance cover the claims related to COVID? I think this is probably the biggest question that our boards of directors are dealing with right now, other than the burning question of do we or do we not open our pools?
For purposes of insurance and actually getting sued directly for viruses, there is a standard exclusion in all policies for purposes of viruses. ISO came out with this years ago due to other virus and bacteria related issues, E. coli, Legionnaire's disease, and it's been standard in policies for years. Having said that, the one place where there may be an opportunity for coverage is, because it's never been tested before, is is there coverage for the decisions a board makes for non-monetary damages? So let's say they choose to close the pool and somebody sues to keep the pool open, that they want the pool open. Not clear if there is coverage or no coverage on that because it's never been tested, haven't seen denials or coverage with reservation of rights yet. It's a completely new topic. But as far as any judgments go, there would still be no coverage. That is basically where we stand on this. So the issue becomes, are we able to have, with any suit, you're going to still have a defense, even at summary judgment level. And if you've done everything correctly, there won't be any grounds for a judgment. But that's treading into your territory.
We'll be dealing about that. I was wondering if Hannah could advance the slide and you could really look at this exclusion of
Yep.
loss.
So if you'll see section B, it says, we will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that includes or is capable of inducing physical distress, illness, or disease. COVID-19 fits right into that.
So what does that mean for associations? In our next slide, we will address a number of questions and we'll give you some answers. Hannah, if you could advance the slide. If sued and there's no coverage, what does that mean? It means the association is going to have to pay for 100% of the defense costs of litigation themselves. So as long as the association is Davis Sterling compliant, the judgments will be against the association, not individuals. So we know there are certain thresholds based on the size of an association and the types of insurances our boards of directors need to carry for the association in order for them to be entitled to coverage. And we want to make certain that the association is properly covered so that if we are faced with a situation where there is no insurance coverage, that we will be dealing with any issues or actions against the entity, the corporate association entity, as opposed to individuals. What kind of alternative risk management techniques, Elliott, can we incorporate?
You can be looking at waivers so that people waive their right to sue at the front end before they use the amenities. Swim at your own risk, sign postings to say that they're taking the risk into their own hands, making sure that you've got everything up to current compliant with the standards that are expected of a public set of amenities like a gym or a pool to properly avoid negligence and being so that you're properly protected.
One of the things that we see throughout the different counties and cities throughout California is that in order for compliance in opening an amenity is concerned, that all counties want the associations to be able to provide the cleaning material, so the sanitation or sanitizing cloths to the members if you're asking them to clean up after yourself. And that seems like a really small thing, but it is an alternative risk management technique. We are trying to put the association in a position where all of the risk is behind it instead of in front of it where we have to walk through it. So these are advanced techniques. And then if you want to address the last bullet point in this slide.
Sure. Some things could still be covered if you can, whether it's illegal or virus related. So if they're suing based on your failure to make a decision, there could still be coverage.
And I think that's a really important distinction because we're trying to keep the door open and to make sure that our associations and their boards of directors are obtaining the coverage and, as applicable, the insurances that will protect their interests. So let's talk about, to have that coverage, Elliott, from an insurance standpoint, we have to look and make sure that our boards of directors are not acting negligently.
Absolutely.
You could look at the next slide, Hannah.
So if there's a failure to behave with a level of care that someone of an ordinary prudence would have or exercise under the same circumstances, the behavior usually consists of actions, but can also consist of omissions. So if you're talking about situations where you need to be prudent in what you've done, are you using common sense to make your decisions so that people don't get hurt? Have you done everything you should be doing as a board to make sure your homeowners are still are as safe as they can possibly be? If you're doing that, you're complying with all
Virtually, with the boards that we've been working with, that
Yep.
is number one issue for them. How can we keep our residents and our homeowners and our residents safe during this period of time? And if we go over to the next slide, Hannah, we're going to talk about exactly how we prove that one is not negligent, so that we can try and tie into some of that coverage that Elliott was just addressing. So the first thing is we need to make certain that our boards act consistent with their fiduciary duties to the associations. And the truth is, we could spend an entire session, probably an entire day, on what type of obligations a board has in meeting their fiduciary duties to the associations. But one of the ways that they do that, and they meet that, this is in order to prove that they're not negligent, is by following the business judgment rule. And that's a term that really means that the board members are acting in the best interest of the association. There are a number of different subsections to that. So when you are determining or evaluating to determine whether or not a board member or board members have acted negligently, you need to know that you're going to be compared against other corporation board members. But you're not going to be compared to Apple or McDonald's board members. You're going to be compared to other nonprofit mutual benefit corporations and those persons' board members. So sort of a like for like comparison, because we know that for nonprofits, it really is a whole different board ball game. It doesn't mean that you don't have the same responsibilities. It's the same corporations code for profit and for nonprofit. It's just that you as board members are entitled to indemnity so long as you go through and you meet your business judgment obligations. And what does that mean? We want to put you in a protected position should somebody bring an action against you in the association saying that you didn't comply. So really, what does it mean? How do you become compliant with the business judgment rule? And it's part of the Corporations Code. It's section 7231 of the Corporations Code. And it says that a director shall perform the duties of the director, including duties to a member of any committee of the board. So that's something for us to be aware of as well, because we know boards are using committees heavily at this point in time, and we will address that specifically in a while. And the board member has to act in what they believe to be the best interest of the association in good faith. You're obligated to make reasonable inquiry so that you really get to answer the questions that are before you, and that you're in a position to make an informed decision and rely on the advice of experts, and really show due care in meeting each one of those functions so that you're able to establish a course of pattern and conduct that shows that you acted with that best interest. The goal is to put up the shield and keep you behind it so that we are in a position to provide you the protections and get the minimal coverage in this situation when viruses are excluded, and making it as maximum coverage for you as possible. Remember, under your association's governing documents, a board who is compliant, meeting their fiduciary duties and business judgment rules, will also be entitled to indemnity from the association. And what this means is, even if there is not insurance to cover a particular lawsuit against the association and the board due to the virus exclusion, if there's not a workaround that can be accomplished, our board members are still going to have indemnity coverage under the association's governing documents. The next thing, and next bullet point, is in order to show that you're not negligent, you have to comply with government orders. So although I was talking a moment ago about Big Bear Lake deciding as a county that they were not going to enforce the state's orders because they just did not have the bandwidth, the personnel, or the costs to do that, you don't have that luxury. You can't say, yeah, we're not really gonna worry about that. Social distancing, not our problem. Face coverings, not our problem. You don't get to say that. It's all your problem. And you have to make sure that you are compliant with your county and city requirements, not only because you have that obligation, but because it will help us to establish that you are not negligent in performing your duties. We are looking for you to share or offload the risks that you are taking and the association is taking in order to make sure that you have the coverages that you need. Next slide, Hannah. So I'm sure that Elliott wants to chime in on this as well, but I think it's really important for us to understand that we have different reopening standards throughout the state. So we have the state standards, we have the county standards, and we have our local standards. There are 58 counties in California, in excess of 400 cities, and each one has different standards for each of these amenities: tennis courts, golf, pools, gym, playgrounds, meeting areas, meeting rooms. And one of the things that our boards have to do in evaluating the reopening standards is to distinguish what are orders and what are guidelines. So we know that the county is coming out with orders, the state has orders, and then we have cities that have guidelines and CDC that have guidelines. Can you speak to some of that as well, Elliott?
Sure. When you're talking about, let's say, a CDC guideline, it's prudent to be following it. And it's prudent, you have to follow all of your state and county guidelines, orders, or else you're not compliant. And not being compliant is the first level of not being negligent. If you don't have it, you need to be completely in order. So if the state or the county is telling you you have to have your hand sanitizer in the gym to be able to use the equipment, you got to have it. It's not an if, it's not a choice. You have to do it, or else you're potentially negligent. Same thing, there are prudent guidelines. So people should wear masks when using the equipment and being 6 feet apart. So if your equipment isn't 6 feet apart, you need to move it to be able to get it to where it's supposed to be. These are all basic guidelines, and you need to work from there. Each county being different, as Sandra said, and having to work and know exactly what your particular city and county guidelines and orders are, and they change daily. So you got to be on top of it, literally on a daily basis.
So I agree with that. You do have to be on top of it on a daily basis, and the opinions you've been provided today from your association's legal counsels literally could change tomorrow. But there are certain things that you want to make sure that you do, and that's without fail. If you have a county that says in order to open, you have to fill out documents and attest to them and post them, for example, to reopen your pools. And you have to post them on the exterior of the area where somebody will enter into the pool deck and the pool area. You need to post those. The idea is to offload that risk by letting other people know this is what's required for us to open. We have complied and we are going to open the gates and allow you in. But as Elliott said earlier, you are still going to be subject to coming in and assuming the risk for your use of these common area facilities. We have no case law on this issue yet. It is new, and we believe the higher the level of compliance that there is, the easier it will be to defend the actions of the board of directors and your associations. We recognize there are some unique situations that don't have explicit guidelines. Like, I haven't seen any rules anywhere for, hey, have you played badminton on the association's green belt? We're really not talking about that, and thank goodness if we're talking about a green belt, we're outside, so we're at less risk. But we know on the big ticket openings that we have guidelines throughout the state. And if you remember when you're deciding to open, that you also make the decision for full compliance within the association's best efforts, you will really be in a better and more protectable situation. Elliott?
On top of that, you just, once again, those things that are most likely to come in contact with other people, your gym and your pool, is far more complicated and needs to be watched much more carefully. And there's going to be a far larger quantity of rules and guidelines to follow than a golf course or a tennis court. Once again, open space, and by the nature of what you're playing, social distancing.
So let's talk about face coverings for a moment. We know that our governor has said face coverings are required when you're outside or in a public space. Don't mean outside in the open air, but outside your home or your unit. So we know that there are certain exceptions. There are exceptions for children that are 2 years of age and under. We know there are exceptions for people who have acute health conditions that they don't have to wear face coverings. There are exceptions, of course, if somebody is in an unconscious state and would not be capable of putting on or taking off a mask by themselves. These are all exceptions to the rule. So if you establish that you're going to follow the rule, you can take advantage of the exceptions. And also another one that we've already been dealing with are persons that are hearing impaired, which is a identified disability. They are not required to wear masks, and they are not required, the people who are speaking or communicating with them are not required to wear masks. Persons who are deaf will need to both see the facial features and movements of the face, and for those that lip read, will need to be able to see the lips. So if you are dealing with compliance and looking at the guidelines, you'll now know, okay, so we have to do this and we don't have to do that. We have associations throughout the state where board members are dealing with homeowners who are saying, I'm not wearing a mask. And they are, in many situations, making it a political statement. So we are clear. We are not making this a political statement. Elliott isn't, I am not, and ECHO isn't. But the reality is, in our state, our governor has said, wear masks. The CDC has said, wear masks or face coverings to make sure that the nose and mouth are covered. So our associations say, what do we do? Somebody comes out in a condominium building into a common area hallway and they're not wearing a face covering. We say, you need to wear a face covering. And they say, I don't believe it. I'm not wearing that face covering. What's an association to do? In situations like that, we know that attempts to enforce any requirement that's a governmental requirement is really without enforcement power as far as to do something about it for the non-compliant owner. In situations like that, we may suggest that a board implement emergency rules and regulations concerning the required conduct that the board of directors, in meeting its fiduciary duties, believes that it's in the association's best interest that there be compliance. And then we can have an emergency fine policy so that if a member is called to a hearing before the board on that issue, that there's some action that the board can take. No one wants a fine over this. No one's looking to make money on it. We are looking for compliance to keep our community and our members healthy and allow our board of directors, to take positions that really will best protect the association. We have the good fortune of representing associations in 40 of the 58 counties. So literally, I have an associate every morning that spends 2 hours just updating all of the county requirements throughout the state. So when I receive a communication, whether it's a phone call or an email, then I first look at the zip code to make sure that I have the current status on the law in that particular geographical area. And I'll tell you, the differences are amazing. We have differences in Los Angeles, Orange County, San Francisco, Marin, and each are requiring different standards as to what can be open, but also how they are supposed to be open. And so we really need to be mindful of the fact that our immediate area, so we've done the county, we've done the state, we've done the county, and now we're going to look at our city and look at what orders a particular mayor has established. So in San Francisco, for example, we have to be compliant with San Francisco Department of Public Health, which requires that if 3 or more people in your community are tested COVID-19 positive, that they need to be advised of that, because that's what they deem to be an outbreak. Pools are still closed in San Francisco. So either we don't have a lot of board members from San Francisco on the line, or they're preparing for when we hope that moment is going to happen, when our pools can be opened. We're allowed in San Francisco, for example, to have outdoor exercise classes, but we're limited by a number of people. By the way, back to pools in general. Most of the counties are requiring at 50% occupancy or a stated number of people. And it's literally based on a mathematical equation of the volume of water and how much space each person actually assumes in each particular area. So we want to make sure that you're familiar with those guidelines before you open your facility, so you know what your obligations are in your particular area, and we'll put you in a protectable position. Elliott, you want to talk about the next slide? Elliott?
Okay, so notification signage. When you're putting up a sign, use at your own risk, it now moves the responsibility from the association to the individual unit owner making their own personal decisions. Taking the burden of responsibility away from the association and placing on the individual owner. You give them the facts about what's going on in the pool area or in the gym area and what the risks are, and that you've complied to the best of your ability, and then they can make a decision as to whether or not they want to take the risk.
And that issue of whether or not they want to take the risk really leads us to the second bullet point on this slide, and liability waivers in households. And what about each member in the household? So we are advising our clients that they should strongly consider requiring liability waivers from any adult that uses the pool, and any adult to sign a liability waiver on behalf of their minor children. And the reason that we are doing that is to establish this hierarchy that we gave you the option to come in or not, but in order to come in, you have to sign the liability waiver. This is an effort to protect the association and, of course, its board of directors. It brings the issue of risk to the forefront with the person who's going to be signing that liability waiver, and it lets them know we are doing the best we can, but we cannot make any assurances here that there are surface areas or touch points in our pool area, on the deck, in the area that's going into the pool, in our public facility, public in a private sense, in our associations, restrooms, that could have a touch point that could expose somebody to the virus, and having them accept the personal decision to sign the liability waiver. Some people are saying, well, why can't we just have one person in the household? Why are you making us sign each person? Because it's an individual waiver, and we want to make sure that any person in that household that's signing that waiver, who's of the majority, meaning that they're an adult, is making an informed decision, and the people who are guardians or parents of children are making an informed decision about assuming that risk on their behalf. This also helps us to prevent the allegations of negligence, but defend against it. That slide that we looked at a few minutes ago, to put our boards of directors in the best position that they can be in to protect themselves and the association if, in fact, even after doing everything right, something actually goes wrong. If you don't look at these steps for compliance, and you don't look at how you can offload certain of the exposures to liability, we don't know how you'll actually be able to defend yourself if you don't go through these processes and procedures. So just this morning, somebody sent me an email and said, oh, I'm attending your ECHO seminar today. I'm really looking forward to it. Can I ask you a preview question? And if you're on right now, I didn't have a chance to respond. I'm going to do it right now. And that is, will these liabilities waive up? Will. And the reason that we say we think they will is we don't know what laws will evolve that will protect people who contract COVID-19, and whether or not there's going to be public policy decisions, or the courts say this was a pandemic and there was no defense to asking people to sign the liability waiver. As an attorney, I think that they are, as if they are well drafted, do provide you the protections you need at the very least to prevent allegations or to defend against allegations of negligence. And we believe, and I've seen not just the ones we've prepared, but my lovely competitors who have really turned out also very good work product, that these documents are written to be acts of disclosure and assumption of the risk. Any comments, Elliott, on enforcement or lack of enforcement other than what I've addressed?
No, not really. I just amplify the fact that you have to enforce all of these, everything you're doing uniformly. You can't let it, you can't pick favorites. You can't let things slack just because the guy's a friend of yours.
Or just
you don't want to offend somebody.
Or because somebody says, I'm against this, I don't believe this, this is a hoax, or whatever their personal beliefs may be. We take the position that opening of these amenities are permissive, not mandatory. The state is not saying you must open your pools, you must open your gyms. They're saying you may, so long as you go through all of these procedures and requirements. And it's our belief that both from an enforcement and from a waiver of liability standpoint, if you go through that process and diligently enforce, the waiver will be upheld. Hannah, if you could advance us to the next slide. So we'll let you take the first stab at this, Elliott.
Okay. Indemnity. When you've, the boards are all protected by the association because of Davis Sterling guidelines for their decisions that they make. And if you're getting people to sign waivers, they're indemnifying you, and they're making sure that they're giving up their right to sue you because they got sick at your amenity. They're now taking on, assuming the risk. And compliance, if you force mandatory compliance with this to use the amenities, you're using a uniform set of guidelines, so nobody can say, You pick favorites, you discriminated here, you discriminated there. If you didn't do it right, you didn't comply, that goes away. You're done what you're supposed to do according to the state. You're safe, or should be safe, from negligence, which is what we're trying to maintain here and what we're trying to get to a level of. And by having waivers and having swim your own risk signs and use your own risk signs and providing the PPE to be able to use the equipment safely, you're sharing and off-billing the risk to other people, back to the owners, who can then make the decision as to whether or not they want to do it. If they don't like wearing a mask, that's great. You just don't have to use the amenities. That's simple.
So simple for us, not simple for people who want the amenities and, you know, claim their civil liberties are involved in. And, you know, our objective today is to provide you with the guidelines in a situation where we've really never dealt with this before, that there's a non-insurable component to the governance that our association board members are engaging in. So we're not going to have insurance coverage to defend a claim where the association opened and someone got COVID-19. What about the situations where there's an example of decisions made where the carriers will defend, where somebody sues the board of directors for breach of fiduciary duty, loss of use, or suing the board because they failed to open in a permissive environment? Do you think we'll have an open door to insurance coverage in either of those situations?
When you're talking, I believe there will be coverage. Hasn't been tested yet. There has been no cases. There's no case precedent on this in any way, shape, or form. But having said that, there's a duty to defend. And it might be with a reservation of rights, meaning that they're going to defend you until they can figure out whether or not they really have to defend you.
And it means that anytime during litigation, they could say that we reserved our rights and now we are canceling the coverage.
Correct. They can say, we're no longer providing the defense because we don't feel that there's coverage under the contract.
So it's really, you know, I've spent years teaching boards of directors about their responsibilities as board members under the governing documents in a variety of state and federal statutes, federal as it relates to, you know, acts of discrimination, hostile work environment, employment matters. And one of the things that we've always taught our boards is make sure you have good D&O coverage, because that is going to protect you if the association and the board of directors is sued. We have to change.
Absolutely. And there's two distinct types of contracts out there for boards. Some cover non-monetary damages and others exclude them. What we're talking about here are non-monetary damages that could potentially have a defense necessary.
So meaning you didn't open the pool, or you did.
You're not getting sued for money. You're getting sued to do something. So if you're getting sued to open the pool or to close the pool, or I don't want to wear a mask while using the pool, those are all non-monetary. Those will all be non-monetary judgments. And if you have a contract, if your D&O policy excludes non-monetary damages and non-monetary suits, there's no coverage. You want to make sure you have the best possible directors and officers policy out there.
So isn't it's standard, isn't it, to have non-monetary coverage in D&O policies?
No, there are several carriers that exclude it. The typical endorsements that go on your package policy exclude it.
So I think it's extremely important for those people that are attending our session today that they really understand that almost without question, no two D&O policies are the same. And now more than ever, you want to make certain that you have coverage for non-monetary claims, because if you're going to suffer from a virus exclusion, we need to have coverage so that we have the appropriate protections for our boards of directors for non-monetary claims.
Absolutely.
And we want that, let's say somebody sues a board of directors to, they file a lawsuit to force a court to order the association to open the pool. The homeowners want it open. Another suit is brought forward by homeowners that want it closed. Would those be the type of claims that we would still have coverage for if the policy said that it included, or as opposed to excluded, a monetary claim?
Absolutely. My understanding is that yes, it would provide coverage for that, and that it would provide coverage, and there is an opportunity to have a defense provided, because you're no longer suing for the virus, you're suing for the decisions of the board. There's a major distinction between the two.
And I think that major distinction really requires a review of the insurance policies, communications with the insurance agents to see whether any additional riders can be added to a policy, even in the middle of a policy year. Is that possible? I mean, I know.
Absolutely. Sometimes it might take a cancellation and a rewrite, but we're not talking large premiums here. D&O is the small portion, a very small part of your insurance budget for the year. And it's the most important part for the board. So it would be prudent to have a second look at this and make sure that you have the right coverage in place. Absolutely. And these are new territories, so most agents aren't even aware that they need to be worrying about this.
And, you know, with all respect to everybody, can't blame them. None of us have been dealing with this issue before.
Absolutely. This is all new territory, unless you specialize in condo associations, and specifically the contracts we're dealing with. Here, you can't stay on top of it all. This is literally a changing bullseye on a daily basis.
So even if those of you that are specialists in insurance for homeowners associations, dealing with these exclusions, such as for a virus, although they may have been contained in the policies somewhere on the 87th page and the third line from the bottom, it's really the first time that we've been dealing with the concern and already the carrier's statements that there are no coverages for COVID-19 claims.
Absolutely. This is something that was not this is new territory for condo associations and homeowners associations. Not so new for food service. Food service has been dealing with viruses for years and years. Every time there's an E. coli breakout or some other mishandling of food. But this is, HOAs have never had to deal with this.
So there are associations that do have to deal with it if they have mixed use associations. They have master associations with clubhouses that have eating facilities with
Maybe
clubhouses.
on that side of it, they're not actually producing the food, where that was normally a problem in the past. Past history in the insurance industry is when you're actually physically preparing the food. Most HOAs don't have food prep as part of their amenity. They might have a kitchen, but the kitchen's food prep is now done by whoever's coming in as the caterer, and they're protecting the association.
So when you say they're protecting the association, I'm assuming you mean by the insurance coverages that they...
Exactly. So they'll extend additional insured coverage on their policy to the association. And they're the primary person who's handling the food. They're the ones that get sued. Association gets named as additional insured. It's never been a problem for the association previously. This is the first time the association has been the primary for having to deal with the safeguarding of the equipment or amenity.
So I would say that it is a newer issue to deal with for associations that are mixed use, where their
Absolutely.
association actually is serving food in cafes or restaurants. And we do ourselves have a couple of those communities throughout the state. So this really requires an additional conversation by the boards of directors to see how their coverage will play. They want to make sure that they have coverage on the association side, and then they have coverage on the indemnity side. And all of this goes back to this third bullet point on this slide, which is to share or offload the risk. Get somebody else or some other entity to be responsible for this potential liability that the association can be exposed to. So Dave, I can see that questions are coming in fast and furious. We can start taking some of them on the topics that we've addressed, or possibly there's something that we didn't address that somebody would like to ask us a question.
We still got just one last slide after this one. I think you guys, a lot of it got covered.
Let's look at that.
Yes.
We've already covered this, but we'll go over it one more time. Claims about decisions made. So this is once again what we were talking about when we're talking about non-monetary claims. So when the board makes a decision, it's no longer an issue of the virus. You're now being sued for what you did or didn't do as a board. There should be coverage for that. And they should now have the association should now be covering you for your defense based on that.
So let me raise a question here. If an association chose not to open their pool amenity for whatever the criteria, they didn't feel like they could financially afford it because of the additional cost that's required to keep all of the pool area, the deck, the touch points, the bathrooms.
Yep.
They chose not to do so. And somebody sues the association for that decision and a demand for reimbursement of assessments because, of course, it must be much less expensive to run the association. Now, the amenities are closed. We know that's not the case, but it is the perception that many people will hold. If that lawsuit happens, where they're seeking, where the basis is the non-monetary decision, we're not opening the pool, and then they bring in the monetary component, which is we want a reduction or reimbursement or rebatement of our assessments, what would that claim do to the non-monetary claim?
Good question.
Thank you, thank you.
It is actually gray area. It may kick it to the general liability coverage, which would then fall under the exclusion. May not be. It depends on how the complaint is worded. It really comes down to the wording in the complaint.
So we have had literally hundreds of associations throughout the state asking for advice on this very issue. Our homeowners want money back, and we are over budget trying to deal with these issues. What do we do? And the answer is, let's look at your policy, get your agent on the phone so that they can review policies and give you advice. I think some of the things that our boards make a mistake about is they think the relationship is with their insurance agent is, please bind this claim. I'll write you your fee, and I'm including the amount to bind the coverage. And what happens when there is a claim. I personally believe, as a professional that our boards of directors rely on, those two situations are not the only time that our board should be communicating.
God, no.
Agents.
They should be contacting every time they have a question of whether or not there's a liability issue. Just like you contact your attorney, you should be contacting your insurance professional. So to figure out whether or not there's coverage under your contract for whatever it is you're thinking about doing. It's the natural way to make sure that you're cut. If there is no coverage, is there a way to now buy coverage to make sure you're properly protected? So
I imagine that some insurance companies and some insurance agents are going to look for those workarounds on those virus exclusions to deal.
absolutely, there are places that will sell you coverage for virus. It's obscenely expensive and it's unique coverage, not typically ever bought by HOAs previously, never had a need. So yeah, there are places that will sell that coverage and add it back into the contract.
Before a board makes the definitive decision to open or to choose to remain closed, and this next week, I think that's going to be a hot issue again, because with the incredible rise in the number of COVID cases in the state, we may have more common area facilities that are closing again, either by governmental order or by board decision in evaluating whether or not they could really sustain a defense against a negligence claim if they stayed open. I would suggest that before that decision is made, a call with your agent to address the available protections if you choose to open or to close after being open is in order. And now I think, Hannah, that we've covered those slides. Is that correct?
Yeah.
All right.
Yes. Okay. Well, now we'll move into the Ask the Experts Q&A session, and this is sponsored by Eckham Painting and Allenson Insurance Agency. So thank you both for sponsoring this Q&A session today. We have, let's see, quite a few questions. And let's see. What is an HOA's liability to not sanitizing common area touch points such as elevator buttons, doors, to storage areas, trash and recycling, man gates, etc.?
So we know that the state guidelines, I'm not talking about county, that the state guidelines are requiring compliance with CDC guidelines. It's the guidelines phrase that really creates the issue of whether or not the liability is exposed. For me, when I see the CDC say, we want you to be obligated to clean those touch points, I take that seriously. And I think that the association does have the responsibility throughout their common area components within their ability, their budget, and their skill set to make certain that there's an attempt to sanitize those touch points. What I am seeing in almost all of the county orders, and I mentioned this before, is asking the homeowners to bring those sanitation wipes with them. If you're going to transfer the responsibility back onto the owners, will not let the association off the hook. So for example, in Ventura County, which is in Southern California, that county takes the position that you can transfer responsibility, in answer to your question, to the homeowner, but you have to provide them with the cleaning and sanitation devices in order to effectively transfer that to them. So at the beginning of the pandemic, you couldn't get a sanitation wipe for love or money, no matter what you were willing to pay for it, let alone hand sanitizers. That's why everybody was making their own. Now, of course, they're more readily available, and the boards need to be mindful of the fact that if they're not going to have it done, and they're going to tell the homeowners they're responsible to do it. If you take the elevator, clean the buttons as you're getting out, make sure you provide those wipes at the entrance to the elevator so that the owner can actually meet the requirement.
Sandra, you cut out just on that last bit. Do you mind repeating like just that last tail end of your sentence?
If the association is going to transfer the responsibility to the owners to clean the touch points that were brought up in this question, you have to give those homeowners the materials with which to attempt that sanitation. Otherwise, you will not reduce the association's liability if they fail to carry out their responsibility.
Thank you. We'll get to the next question. Do you have any suggestions or recommendations for owners that are continuously ripping down signs posted in the common areas?
So numerous counties of the 58, I think in excess of 20, have addressed this issue by saying if it's torn down, the association is obligated to put it up again. If it needs to be laminated or put on rings that attach to gates or handles, do it. And this is one of the offloading the risk requirements. It is my opinion, in order to effectively offload that risk, is for the board to make the decision that this is such an important issue, interfering with other owners' ability to make an informed decision, that it is worthy of an emergency rule and fining, which could include, by the way, suspending that owner's ability to use the common area facilities.
Great, thank you. That was helpful. Would you suggest that a person sign a waiver each time they're using the pool, or just once and then they're good for all their continued uses after that one time?
I'll let Elliott answer it from an insurance
From an
liability.
insurance point of view, once you sign that waiver, you're good. As long as you've written the waiver correctly, it's going to cover from then going forward. From an insurance point of view.
Until it is withdrawn. So the only thing that I want to point out for our participants today is that you must have a system to identify if somebody has withdrawn a waiver that had been given to the community. So wherever you're keeping as part of your corporate records the signed waivers, so that you're in a defensible position, offloading that risk, the withdrawal of that waiver is also kept so that you can make certain that household and that person in the household cannot access into the amenity unless they sign a new waiver. Remember, permissive as opposed to mandatory. And if you want us to permit you to come in, you have to have an effective signed waiver.
Okay, we've got Elliott, this one. There is an attendee asking for some clarification. They said you said, one, you are hit with a non-monetary claim, your DNO probably doesn't cover it, and two, if you're sued for a board decision such as a decision to open the pool, are those contradictory, or just a little bit more clarification?
I said most
two?
contracts do cover for non-monetary. Not all contracts do.
Okay.
You have to review those contracts to make sure that you have the right coverage. But if you have coverage for non-monetary damages, then you will have your defense. So
right,
if they're suing, and likewise, it depends on what they are suing for. If they're suing because they contracted the virus, that's going to most likely be excluded under the virus exclusion. If they're suing them for failure to open and close an amenity, or their ability to open and close an amenity, that's going to be a non-monetary damage, different creature.
Great, thank you. So if there are owners that are doing, say, hair or nails in their unit or on their patios, if someone gets hurt on the property, who would be responsible for that?
Okay, that goes back to your general liability coverage. This has nothing really to do with COVID, but this is back to if it depends on where they get hurt. If they get hurt in the common area, you're going to have an exposure to the general liability coverage of the association.
Elliott, what about that we know that nail salons in I believe all counties now are effectively closed. We do know there were some orders that came out the end of last week that if your salon can be conducted outside, that then you can get your manicure and pedicure. What happens if a homeowner invites, knowing that the salons are closed, a manicurist into the building and into their unit, so they're a guest or invitee of that owner? That person passes through our common area, is COVID-19 afflicted, and we have others in the community, if we can go backwards and trace, that we find we're able to trace it back to that person. Will the association have any liability by not saying to their residents any public restriction on services cannot be brought in-house? Is that even possible? Or is
I don't see how a board could possibly restrict that. They can't ask it unless you've got somebody asking every person walking through the door, who are you? What are you doing here? There's no practical way that I can see for the board, for the association to restrict it. And that's a personal responsibility. The person's walking through a common area. Board has not done anything that's particularly negligent in any way, shape, or form. They haven't done anything.
So is there, my final question on this, is there any liability to a board who doesn't do what you just suggested, which is to ask each person, who are you coming to see and what are you doing here? Is that an obligation from an insurance standpoint?
No, from an insurance company point of view, that's not anything they've ever expected in the past. So going forward, it's not a standard of care that's expected of the association. Because most associations have nobody at their front door, nor are they equipped to do so.
Okay, we're all going to remember you said that if somebody brings that claim. Just teasing.
Once again, this is completely new territory. So using past logic in past cases, that's what I'm working from. Hundreds of these in the past, thousands.
Okay. Are there any methods that either of you are aware of that prove that COVID came from the pool or somewhere on the property, a common area? Are there any ways that you're aware of that have come about thus far to prove that?
So it's sort of interesting. We're all really concerned about this issue, and I'm right at the forefront of being concerned about it. But we know our federal government and our state government failed at tracing. So why we really think that our associations are going to have more success with this in tracing is really somewhat mind-boggling, but it doesn't take away from the obligation. In preparing for today, I actually just learned this week that there's a reason in the protocols that people are encouraged to take showers before they go into a swimming pool. And one of the reasons is that within a 60-second rinse-off shower, you are rinsing off 96% of the probability, if you have COVID on you, that it will not make its way into the pool. And one of the things that you want to do by requiring, if you have outdoor showering facilities, that's part of your protocol to use the pool, is if you don't, when somebody gets into the pool, they're using the resources of the chlorine or bromine, whatever your association utilizes in your pool. They're utilizing those materials to break down the COVID on that body, the virus on that body. and taking away from its ability to spread throughout the water. What we've seen in all of the studies to date is that it's not really transferable through water. These are all precautions that we have to take so that we don't introduce that transference into water. It's one of the reasons why outdoor pools throughout the state were opened more quickly than more confined spaces like gym or fitness facilities in associations.
Very informative. That's something, not something I personally knew. So thank you.
Hannah, we had one question earlier about HOAs requiring homeowners to take periodic and regular tests of whether they have COVID or not. I answered it, but could you go ahead and speak to that for us, please?
So I don't know how you answered it, and I don't want to embarrass you. There's no authority for the association to require that. There is an authority if the association has an outbreak with employees that they can require it before return to work if that's part of their policies and procedures. Because we're talking about insurance exposure and liability, I would like to address what suddenly seems in the last 8 or 9 days to be my hottest topic, and that is boards who believe that there's some obligation that the association has to out the people who are affected by COVID-19 and even their employees. So although Dave was very clear at the beginning, and I'm going to reiterate right now that we're not giving legal advice, call your own lawyer if you want to rely on something, I want to be clear that there are numerous laws that really keep you from disclosing who has COVID-19. The things that should frighten you in making that disclosure, it is a HIPAA violation. And although we are not medical professionals releasing information about our patients, the governmental orders have said we are bound by those requirements, which only have very few exclusions, and the exclusions are only in relation to healthcare providers and their patients. So we're bound by HIPAA requirements to be quiet, yet the only exclusions are those persons who really are engaged in HIPAA protected activities. The other issue that we have concerns about with disclosure is that the ADA has defined COVID-19 as a disability. And we certainly know that associations are prone to liability if they don't properly act upon a disability claim. There is, I understand, there is the counter argument, if I don't know it's Mary Jane who lives next to me on the 27th floor of our high rise, how am I supposed to protect ourselves? And I understand that argument. I just don't buy that argument because of the obligations for confidentiality, not to mention the state obligations that we have for under the government code for privacy protection of our employees. So what you want to do is send out a notification saying in our building or in our community, even for planned developments and our standalone condos, unattached condos, that we need to be clear that yes, somebody has tested for COVID. Please do everything you can to protect yourself. Here's what we are doing as an association in response to this. And I suggest to our clients to then say in that communication, please do not contact us for additional information in order to protect our residents and our employees. We will not provide additional information to you.
Thank you.
Our next question is, so when you guys were talking about waivers being signed, is there, does a witness need to be present when that waiver is signed?
So I think from a legal perspective, if the resident in the unit turns in a waiver, and they turn in that waiver in person. They turn it in electronically, let's say with DocuSign, and it's coming from their established email address. I believe that the association has the right to rely on the fact that it is that homeowner who signed that waiver who was sent through their email address. From an insurance standpoint, I'll throw that, of course, to Elliott.
I'm exactly the same. It's assumed that that waiver is going to be signed by the right person, by the person. This is not the insurance companies. I don't see it caring one way or another on that side of it, demanding the witness signature. It's a level of care that's beyond what is expected from an insurance company.
I do know some associations are requiring the waivers to be signed on site the first time that they come to use the association's common area pool. And that works well for those associations that have the benefit of on-site staff that can do that. Some associations are saying, can we have volunteers that can help us? I am concerned about the use of the word volunteers. I'd be much happier if we use the phrase, can we have a committee member do that? That's, of course, assumes that the board of directors will have established a committee correctly under both its governing documents and the state statutes, so that if there is insurance coverage, they will be covered under the umbrella of the association policy.
Yep, exactly correct. Although some of the policies extend once again to volunteers, all of them, almost with the exception of one or two, all extend to chair people.
Committee people.
Committee people. Absolutely. Better way to do it because you guaranteed your coverage.
One of the attendees has a statement that they want to make sure that they're understanding it correctly. And the statement says, just to be clear, if we choose to open our facilities, the association and board of directors can still be sued and would have to incur the cost of defending the suit regardless of how many precautions were took. Is that correct of them?
Yes, depending on what the suit is. If they're being sued for a virus, unless it falls under what we were describing as non-monetary damage suit, it's going to be, it's not going to be covered. It's going to be it's going to be an excluded loss, and they're going to have to provide the defense.
Thank you. What liability does the association assume if the landscape committee needs to meet to walk the grounds and meet with the landscape provider?
So we're talking about the grouping of persons together,
Right.
And whether or not they will be exposed to COVID-19 by any of the people that are part of the committee. We are really taking a strong position, and I really thought, I'm going to be honest, that it would have been more relaxed by this point, but in fact I see it going in the other direction, that boards really need to avoid meeting in person. And I recognize that when we are looking at landscaping issues, questions, and/or violations, that our board members or our committee members want to see that firsthand. The more people you have going on that endeavor, the more risk you have to exposure. If the board is going to have their committee members doing that, they should absolutely say that we are adhering to the state and local government requirements for social distancing and face covering. An alternative to that is having the landscaper provider be provided with questions and information that they want answers to by the committee, requiring them to go out with their phones or their iPads and take photographs and get that back, or videos, and get that back to the committee members. That's part of what other associations that we've been working with have chosen to do, rather than take the risks that those persons will go out and suffer the consequence of contracting COVID-19.
Our next question, so this person asked, they've been reading debates on whether HOA amenities are private or public areas. Some think they are private and not subject to government orders and guidelines. Any thoughts or comments about that?
As risk manager, can I go first, Sandra?
Absolutely.
As far as I'm concerned, as a risk manager, it's a public amenity. There's nothing private about it. You have multiple people using the same place at the same time. Just like the HOA is not a personal lines exposure, it's a commercial exposure. And it's a commercial policy. As far as I'm concerned, and as far as insurance companies are look at it, that's public.
So when this whole thing started, so we're talking about towards the second or third week of March, we began begging the governmental entities in every county to give us guidance, because we had associations that were saying, well, that talks about a public pool or a public gym. We don't have to close our facilities. And the question that was just asked is really motivated by all the schizophrenic answers that we're getting from governmental entities. Some are saying, yes, it's public. Some are saying it's not public. As we deal with the issue of pools, we know that the legislation and the laws in California say that our pools and homeowners associations are deemed to be public. And how we know that is a number of years ago, we had a big issue with a terrible situation where a child was killed by this suction caused by a drain at the bottom of a swimming pool and could not escape from that suction. And we know that all the associations in California had to have their pools tested along with all public pools. And that was a really serious line in the sand when we understood that for risk standpoint and therefore legal liability standpoint, our pools were going to be deemed public for compliance. And so we have taken the position that we will treat them as public. Our obligations will be addressed as if they're public. And we know that Elliott just said from an insurance standpoint, the insurance coverages will be as if they're public.
Okay, our next question. If a board asks residents to sign a waiver for use of facilities, does that imply that the board is acknowledging there is a significant risk? How well would waivers hold up in court?
So I addressed that briefly before. You never know how it is going to hold up in court until someone tests it in court. And I received an email this morning from somebody who said, well, now that the first case in California has been decided that an association is responsible for COVID-19, how does it change your position on such and such? I was like, how did I miss that? Time this morning researching it, no, there isn't. Somebody filed a complaint. The only way that it made its way to the public is then they said, because of COVID-19, we can't proceed at this point. We just wanted to protect our interests, and the entity that was sued said, because of COVID-19, we're not in a position to respond and we want an extension on the response. There is no case that has been, as of yet, decided that would hold the association responsible. The answer is we are trying to offload risk. We're talking about a contract that has to be well crafted and well designed to provide the protections that we are hoping will be sustained. You know, I'd love to say to everybody, yep, your insurance is going to cover you. And all of these lawyers, such as myself, that are preparing these waivers, they are going to stand any court challenge. We don't know that to be fact, and we don't know if there's going to be public policy decisions. Is it an acknowledgement by a board that there's a risk? Absolutely, it is. You are going through the process and making an informed decision of whether or not to open the pool. One of the things that really is worth mentioning is if you do everything right, business judgment rule, acting in all of the requirements as a reasonable person similarly situated, and we went through the different requirements earlier in today's program. If you do everything right before you make the wrong decision, and let's say the wrong decision here in this particular scenario is you open the pool. And in your case, in your association, your fact pattern, it turns out to be the wrong decision. But in making that decision, the board did everything right, you're going to be protected if we have insurance coverage. But for certain, you're going to be protected under the indemnity provisions under the association's governing documents. That's why we have association boards of directors going through this process. So the fact that it's an acknowledgement that there's a risk isn't something that I would be afraid of doing because you're afraid that it will be used against you later. I think it would only help you in your defense.
Thank you. So we have quite a few questions that people are asking if there's any sort of standard or example waiver that they could take a look at. And I was wondering if maybe Elliott, you knew of one, or maybe Sandra, if you knew of one, or just a place to point them to. But there's quite a few questions of people wanting to know just an example or a standard.
Let's see, you're talking legal documents. I'll let Sandra answer that one.
So I know that all of the law firms that I'm in communication with and my own law firm frequently put on our website, documents that people need all the time. So for example, how people communicate at meetings, protocols for homeowners during homeowners forum. And we put those on, and they're this is it. And we're going to stop your ability to speak if you don't follow along with this. These waivers are not being put on anybody's websites, and the reason is we believe that, and we look at every set of governing documents before we prepare a waiver and we customize it to that association. So I have to say at this point, I don't know of anybody who is providing quote unquote draft waiver, probably because the risk of getting it wrong is so high that we want to put the highest contractual efforts into making sure it is as defensible as possible if it's our last line of defense and we don't have insurance.
Absolutely. You don't want to expose your own E&O insurance for just having thrown a document out there and not properly reviewed it to the CC&R. Can't do that.
Thank you guys. We just got a couple minutes left. I'm sorry guys, we could not get to every single question. There's still a ton of questions, and again, if there's a question that you didn't get answered and you'd still like an answer to it, feel free to email me, hmacauley@echo-ca.org, or you can just email events@echo-ca.org, and I'd be happy to find an answer for you. But I just want to thank Sandra and Elliott for their time and expertise today, and thank you for answering all these questions and all the great content that you guys provided for all of our members and non-members and professional service providers today.
Thank you.
Thank you.
Thank you for having us.
Thank you. And so we're just going to move on to a couple other announcements. I want to thank all of our sponsors again, SwedelsonGottlieb and Elliott Katzovitz Insurance, for being our program sponsors for today. And thank you to our Q&A sponsors, Allenson Insurance Agency and Eckham Painting. Thank you both, as well as our registration sponsors, ASAP Collection Services, Applied Reserve Analysis, and B2R Consulting Group. Thank you all so very much. We wouldn't be able to do these things without all of your help. So thank you so much on behalf of ECHO. And our next event coming up is August 5th at 4 o'clock. It's our virtual legal resource panel. You can find that on our ECHO website under events to register. There is a small fee to register for this event, but we'd love to have you. Again, that's August 5th at 4 p.m. And one of the biggest events, Dave mentioned it in the very, very beginning. If you were on in the beginning of the webinar, he mentioned our 2020 ECHO HOA University and Expo. This is going to be in collaboration with the Levy Erlanger and Company Annual Community Association Managers Conference and Trade Show on September 25th and 26th. So those 2 days are going to be the live days. And then for 28 days after that, the entire event will be on demand for everyone that registers for the event to view at their own convenience. So you don't have to try to cram everything in all in one day. You'll be able to hear content and presentations from the managers conference, as well as ECHO on Saturday. And you'll be able to visit with a ton of different exhibitors and go to their virtual booths. It's a completely different experience, and we're looking forward to having you all with us on that day. Dave, is there anything else you want to add to this?
Well, we do have the Managers Lounge, which is, I think, a really exciting thing that we've instituted this year because of virtual technology. And you can actually go into the lounge and talk to the managers if you have questions about how to manage your association. It's going to be an exciting time. I'm looking forward to the wine auction. That'll be fun too. It's a drawing that we're going to do. So we hope to see you all there, and we really appreciate you participating and tuning into these webinars as well. Participation has been growing pretty significantly, so thank you for that.
Thank you. And lastly, our last slide of the day to wrap everything up. Again, if you were, these webinars are free to HOA board members and homeowners, whether you're a member of ECHO or not, but we do encourage you to become a member of ECHO. There are a number of different benefits to being a member of ECHO, and if you're interested in becoming a member, you can email jprice@echo-ca.org or call the number on our screen, and both of those can be, you can also find the information on our website under membership. But we'd love to have you as part of the ECHO community, and yeah, thank you all for joining us today. And we appreciate all of your time and your questions. And again, thank you to our speakers and sponsors.
Of course. Great day.
All right, guys, have a great day.
Take care. Have a good one.
Take care.
Bye-bye.